Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
Right, we got Mike Alder here today, and I'm really stoked about this because Mike was just at our last conference in Huntington Beach, and he taught a couple classes, and when he filled in, because Chris, our mutual friend Chris Dolan, was supposed to be there, but he was in trial, but he had this voir dire class set up, so Mike was able to jump into it and pick it up from there. So it was very appreciated. I know the students appreciate it because I talked to him afterwards. Like, that was, one guy's like, that made the whole trip worth it. I'm like, that's fucking awesome. So Mike, thank you for that. Well, and where are you at today, Mike?
So I'm at my office in Los Angeles. I'm actually in the Valley in Sherman Oaks. Taking 2 depots today on trials coming up. So I figured we'd do the podcast, spend a little time together before that.
Great. And those depots that you're taking for the trial coming up is actually a trial that we're going to be talking about a little bit later. And so it'll be also the first time that we ever talked about a trial that hasn't been tried yet. And then we're also going to do a case analysis on this trial. On what date did you select?
We've got one on the 9th, but on this case is going to be on the 19th of August.
The 19th of August. So I'm stoked to talk about that because it has a lot of challenges, like a very overweight plaintiff who needs to lose weight and to get help. And that's a real challenge, but we're going to talk about that a little bit later. First, Mike, I know you've been in LA now for quite some time, but that's not where you started out. So how did you decide to move from Louisiana to the big LA, from a little LA to the big LA?
I'm probably like a lot of people who live in LA now. We started in some other part of the country, grew up in a little town in Louisiana, 700 people, country, not a lot of money. Parents were traveling preachers and, but hardworking, and so was I, and went up through the school, and ultimately you're in Louisiana, so that means you go to LSU. You're graduate from LSU undergrad, that means you go to LSU Law School, and that's what I did. And along the way, went from never even imagining being a lawyer to being introduced to the possibility, to jumping all in, to then being told, hey, let's move to LA and see what happens. And so that's what we did.
So how did you, like, the idea of becoming a lawyer, where did that idea first pop into your brain?
Well, I think a lot of people, have stories of, I was imprisoned as a 10-year-old and I wanted to fight for right. That wasn't me at all, right? Probably most people aren't like that. Didn't know any lawyers, didn't even know what lawyers did. Wasn't until I was a sophomore in college, drunk on the front lawn of my fraternity, when a woman came by and said, hey, what do you want to do? And I said, I'd like to have another beer. What do you want to do? And she's like, well, I'm going to go to law school and I'm going to move to Los Angeles. I'm going to become an entertainment lawyer. And we started dating and I was like, law school? What? We got married. I got married at 19, right, to her. Graduated from college and we went to LSU together. And she wound up being first in our class for most of the years. In the first semester, she got a clerkship after law school with the U.S. Fifth Circuit Court of Appeals in Jackson, Mississippi. So here I am going to be in Jackson for a year, 2 years later after I graduated from law school. And I'm a very giving person, so I helped the top 50% of my class get there, So I wasn't some rock star. Didn't know what kind of law I wanted to do. I worked 3 or 4 jobs in law school, one of which was for a tax professor, checking her cites to her law review articles. And get it, this is 1990, right? 91. No internet, no Google, no email, no Shepard, no Westlaw, it was all in the library, pulling out each book, and what a wonderful life. It was wonderful, actually. But I thought I wanted to be a tax lawyer. So graduate, I apply to LA firms to be a tax lawyer, and my grades were not good enough, and I'm from this, they thought, rinky-dink school. Somehow I talked my way onto a clerkship with the Mississippi Supreme Court. So that next year, I was clerking for a judge on the Mississippi Supreme Court while my then wife was across the street in federal court on the Fifth Circuit Court of Appeals. And one of the justices, Chuck McRae, who's a star of that Hot Coffee movie, dynamite, wonderful, amazing man, was the cool justice, like all trial lawyers are, right? So he took all the clerks to his chambers and would give us drinks, and he would tell dragon slaying stories. And here I am, this impressionable young person, and I'm like, well, that's fucking awesome. And I became friends with him, and I'm like, hey, I'm moving to LA. I don't know anybody. I've never been west of Houston, you know? And he pulled out, back then was what was called the Atla Journal, now AAJ. And he told me about Tom Girardi, Brown Green, Larry Feldman, Gary Paul, Charlie O'Reilly, all these people that, 35, 40 years ago were the gods. And he wrote me a letter of recommendation. My judge did as well. And I came out and interviewed, and I was 0 for 7 on interviews. I met all the big dogs, and they said, no thanks. Again, I don't think my story is any different than a lot of people. You don't know where you're going. You don't know really what you're doing. You don't have some big life plan. You kind of deal with life as it comes. You deal with, failure and being turned down, et cetera. And God, what a blessing that all that was, because I was so happy when the number 8 guy offered me a job. Guy named Dave Harney, who was now in the latter part of his life, but was Ralph Nader's lawyer against General Motors back in the 50s and 60s, so it was a blessing to be exposed to wonderful people. So, I mean, we can talk about what happened after that, and that kind of molded me. And so that's kind of where we're at. So I got out of law school, had my first job, and that firm fell apart about a year and a half into my first job, and I got fired. So now what do I do?
So a couple of things here, Mike. One is I know Chuck McRae, not as well as you do, but he is very active with the Southern trial lawyers and and I think even the Western trial lawyers. But so I know him from those conferences for the last 10 years, and people used to talk about him being a Supreme Court justice and what a cool guy he was. And so that,
Amazing.
because when you were talking earlier, when you talked about Supreme Court justice, is really cool. I couldn't remember the guy's name, and that's crazy that is the guy. And you and I went to the law school at the same time because of my birthdays.
And what a humble man, in that I saw him at an AAJ conference, I'd say maybe 7 years ago, right? And I walked up to him and I said, Justice McRae, you have no idea who I am, but sir, you're why I'm a plaintiff's lawyer. I met you. I was Lenore Prather's clerk back in 92. And he was just a gentleman. He said, tell me about you, Mike. And I said, well, I'm this, that, whatever. I've done that. How big's your firm? I tell him. He's like, you know what? Congratulations. Great job. And he shook my hand and he said, I'm really happy for you. I'm like, this guy is amazing. He had no reason to do any of that. But that's what you get when you reach out, when you make relationships, when you reach out to touch relationships. You do it 10 times and 8 people say no, or 2-3 people say no, and 3-4 people just give you kind of you're going to meet 1 or 2 people that are going to change the direction of your life, or introduce you to your spouse or your next partner, or get me a job in LA. I mean, what a wonderful man. And he got voted out in the hot coffee insurance sweep of all of the Southern judges out of office. But Anyway, to continue, Dave Harney was a rock star to the next generation of trial lawyers, one of whom was Mike Pews, who then gave me a job because I worked for Dave Harney. And Mike Pews trained me and several other, Gary Dordick, John Taylor, a whole bunch of people that came through his office. We've all won trials and trial lawyer of the year, and he was the one who exposed me to high value cases, trials, etc. But then I got fired from that job.
Hold on a second.
Right?
But how much time did you spend with Mike Pews? Because he is like a LA legend.
A little less than 4, about 3.5, 4 years. I was the only associate. Mike, no longer with us, was the best trial lawyer I'd ever seen. Kind of a difficult guy socially sometimes to get along with, very demanding, but he gave me the autonomy and the rope to hang myself or to swim in the deep water. And I realized later how much I had learned from him that I really didn't know that I was learning. I mean, so many of us start our practice, and you get your first big case and you're like, well, what's your life care plan? And they go, well, what's a life care plan? And I had been fully exposed to all of that kind of high level stuff, so that when I opened my own firm out of necessity, even though it was out of my house and I had one case, and I put the word out that I would try anything that moved, after a couple of years, when I started to get some better cases, I knew what to do. And that was a real gift and a blessing that I told Mike about, later, and thanked him. And he acknowledged and was appreciative. But, you don't burn bridges.
Let me ask you this, Mike. So Mike Pews, how many cases did you try in that 4 years you were with him?
I'd say probably 4 or 5 by myself, and then another 10 to 12 as a second chair.
A second chair to Mike.
To Mike.
And so what did Mike do? Because he trained you, right? He mentored you. So tell us some of the things he did to mentor you to help you become the trial lawyer that you sit here today as.
It was more by osmosis than a lot of explanation, right? He would explain what needed to be done for the purposes of me doing it. But there is no substitute for watching someone cross-examine, voir dire, do stuff with a knowledge of the facts and the strategy and whatever. And so having the ability to go backdoor at night in trial and listen and learn from him making strategic decisions about which witness and how we're going to do this. And he would teach me about basic things. The very first thing he ever said to me when I first started, he said, here's the secret to being a good trial lawyer. And I'm like, yes, sir. He goes, if they like the plaintiff, you win. If they don't like the plaintiff, you lose. Your job is to get the fuck out of the way. And I'm like, that's silly. Come on. But it's really true. What he taught me was jurors want to help people. To help people, they need to like you. They need to like the jury, to like the plaintiff. And then your job is to make it about the client and about the jury, not about you, but to give the jury the tools with understanding, with cohesive, simple arguments to go from I want to help the plaintiff to I'm helping the plaintiff. And that was a real gift. And him explaining about foundationally, you can't expect jurors who have never seen the case to care about the case and to know the facts like you do. So you're talking about Mr. Harris and Miss Washington and this witness and Dr. So-and-so, and they have no idea who these people are. And even if you mention them in opening, if you don't tell them who they are and repeat it over and over, they're going to forget. And if you talk about damages before they understand that the defendant is liable, then the jurors are not going to be in a position to listen to the damages in a way of digesting it to try to say, okay, let me look for the reasons to find for the plaintiff, if they haven't yet already decided that the plaintiff should win. So you can't put damage people ahead of enough liability people so that the jury already has determined that I should listen to the damage people. So witness order is very important. And then we had talked about, if you continuously understand that you know the file and the facts and the plaintiff and the evidence and the witnesses a trillion times better than the jurors, why not every witness, before you start questioning, put that witness in the timeline of what the jury is trying to determine? So like I said, I'm going to call in this trial. The first witness is the defendant for a whole bunch of reasons. And usually in a personal injury case, your first witness, in my opinion, should be the defendant. I'm not afraid of him or her. I'm taking them on right away. But I also want to get that testimony down so it's not changeable. And if I know that I can get the defendant that's saying things that are not going to be accurate or I can use later to cross, I want that up front, and I want to put it in front of the jury on a whiteboard or on butcher paper, so that later when I have a witness, an accident recon or a live eyewitness, when I say, well, we heard the defendant say that the light was yellow, and it's written, defendant, light was yellow. So then when I've got another witness and I say, the defendant said the light was yellow, the jury, oh, yeah, he did, I remember, yeah, okay. And then when you call your accident recon, again, you got to think about, I know who Al Lowey is, but the jury doesn't know who Al Lowey is. Mr. Lowey, thank you for being here. Sir, you are an accident reconstructionist, right? Yes. And you have been tasked with looking at all the facts and the evidence, and you're going to be able to tell the jury what happened in this accident and what the different parties did. Is that correct? Yes. So now the jury goes, oh, well, now this is the time for me to learn about what happened in the accident. But I see lawyers, Mr. Lowey, could you tell us what your qualifications are? Well, I went to school, and you're 5 minutes in, and the jury's got no idea what they're supposed to learn from this guy. So Mike taught me about that foundational boxing of what you're Dr. So-and-so, you are the treating surgeon who operated on my client. And you're going to be able to tell the jury about all of the reasons why you did the surgery, how the surgery went, and what's going to happen to the plaintiff from now on? Yes, sir. Thank you. So now the jury's like, oh, this is the time for us to learn that. You see what I'm talking about?
I do understand what you're talking about. And this is going to be, that's why I'm looking forward to talking about these aspects of trial, because you got taught by one of the great trial lawyers, and I know that you do a fair amount of teaching and mentoring, as part of your daily, on a regular basis. But so I'm looking forward to that conversation. But I'm following everything you're saying. But let me ask you this: you've done a lot in your 56 years, and you're of this. But professionally speaking, what would you say is the accomplishment professionally as a trial lawyer that you are most proud of?
You didn't ask me that before, man.
Well, I meant to, but we got on these tangents about what Mike Pews had taught you, and so, that's why I do prep. I got to surprise you once in a while.
At this point, I am most proud of the fact that I have evolved into a caring lawyer for my clients that puts my clients first. But also, I'm very proud of the fact that I've learned how to practice law without competing against other things. And I've done on my social media stuff that if people follow me on Instagram or on my YouTube channel, they've seen me talk about work-life balance. And I don't subscribe to that because work-life balance means if I got more here, then I'm taking away from here. And if I got more here, I'm taking away from here. And I think that's a setup in a language system for failure because you're always feeling like you're pulling away from one for the other. I have learned that you can do it all and that you don't have to take from one and that they can supplement and make the other ones better. So, Mike, when are you going to retire? Never. What am I retiring from? I love what I do. I love what I do. I love helping other people. I mean, my life's challenge is to try to help as many people as I can. And my motto in my firm forever that I learned from my, preacher mom and dad was to give unconditionally and not ask for anything back. I get back 1,000-fold, primarily from good karma and feeling for me, but it's also good business. It's also meeting great people. It's not bullshit, and I could care less if you think it's bullshit because I'm gonna keep doing it either way. But it is something that I really get a lot of enjoyment out of. And when people respond, when I'm at TLU, I had in Huntington Beach, so many people come up to me and say, I follow you on social media. I love your videos. You kind of hit the issues that are coming up because I've done it and I know what comes up. I know when Uber and Lyft and Amazon and DoorDash lie about their coverages and say that they're not responsible for. I know all of that because I see it in my own practice in my firm. So, we talked about helping here. I mean, if there are people watching this, newer lawyers, people have some issues with finances confidentially that they would love to go to TLU in Vegas, but they can't swing it. You and I had talked about, I will sponsor you. I will, all you have to do, and I don't know, Dan, if this is on here, but you reach out to my email or my cell phone. And I don't know if it's appropriate to say how to do that.
Yeah, I think so. What's your email?
So my email is CM Alder, Charles Michael, CMALDER @alderlaw.com. My cell phone is 310-710-3345. Instagram is Mike.Alder and Alder Law, and YouTube is Alder Talk. Any of those places you can reach me. Now, I saw your face when I gave my cell phone, and you were like, you sure you want to do that? I will tell you the other things that I talk about is that everyone who watches this very likely was motivated to learn. They have ambition, they have drive to accomplish. And even with that, and even knowing that if you texted me at that number, that I could probably set your ass free with information, 95% of well-intentioned people still don't execute. So people are like, you must be inundated with texts and emails. And I'm like, nah, only 5% of people actually follow through. Oh, that's so pessimistic. No, it's a gift. Shit, I ain't got to compete with everybody at TLU Vegas. I got to compete with about 5% of them because most people won't consistently execute. Most people won't do the things that really help them because they're afraid or uncomfortable or they talk themselves out of it, or they say, well, he'll never respond, or I'm too busy, or I'm not good enough, or he's not good enough. Or we all have this crap that gets in our own way. Why not just pick up the phone right now when you see this and text my ass? Why not? What's the downside? Well, you might not respond. Get the fuck over that. That is what it takes, in addition to being technically a good trial lawyer and litigator. But way more important than that is how you organize your thoughts, your mindset, your body, your health, your routines, your ability to deal with failure, your ability to deal with discomfort. That is what makes every one of these great lawyers on your podcast and on TLU tick. There ain't no one-hit wonders on there, right? It's because they consistently do the things necessary to accomplish big things. And most of that stuff is stuff that they don't want to do, but they do it anyway.
So the look on my face was not one of surprise. It was one of the why stuff, because a friend of mine was talking about business. She's like thinking like, oh, don't you get tired of it? Don't you want to stop being on the road 2 weeks a month and constantly having to create new content, all this stuff, and do these conferences where there's all this pressure to perform? And I'm like, no, I don't want it to ever stop. I'm not done. I'm like, I can't imagine doing anything else. I love doing it. I love being on the road bus. I love being home. I mean, it's like, obviously nobody wants, but just the pressure, the challenge. It's like, it's the greatest thing ever. And I get to help so many people. I get to be a conduit to just help like so many people through so many different mediums. I just can't, I can't imagine not doing it. And that's what my look.
The way you've talked about it means everything. And I know we're going to talk about language that you use in trial and not subscribing to the defendant's language, right? Not using language that in and of itself is a trigger of bad things. But just let's take example of what you said. That person, when they were describing what you did, was saying it in a way that conveyed that it's a negative. Aren't you tired? Isn't it a drain? Isn't it a whatever? How about, aren't you blessed to be able to spread the word? Aren't you blessed to be able to do something you love? Wow, you're in trial all the time. What a gift. Now, same thing, you're still traveling around the world. You're still doing it. But just how you talk about it makes it a wonderful thing versus a burden. Same thing with the jurors. If you talk about it as an accident, maybe they didn't mean to do it, and that means, accidents happen. No, it's a collision, it's a crash. Right? When you talk about a gap in treatment, it implies that there's something that should have been there that's not there. Gap is not the right word. There's a time where they didn't go to the doctor, but that doesn't mean that they should have gone to the doctor then. That doesn't mean that not going to the doctor then means anything. It just means, like most people, they went on this date and then they went on this date. Oh, well, that means they weren't hurt. No, that doesn't mean that at all. It does if you say it's a gap. Degenerative disc disease. They've diseased. Do you mean that they have a spine that is normal for their particular age? So degenerative disc disease just means the way a 56-year-old spine normally looks. Well, yeah, degenerative disc disease. Yeah, you mean their spine looks like a normal 56-year-old who's lived 56 years. Correct. So what you really mean is they're just 56. So they use disease. I use, that's their age. So this person, 42, has degenerative disc disease, AKA the spine of a 42-year-old, and the judge and the jurors. What you're saying is everybody has a degeneration of their spine, given how old they are, that could be completely normal and asymptomatic. So the fact that they have degenerative disc disease that you say, which the fact that they have a normal back for a 56-year-old without anything else, the vast majority of those people have no problems. So you using disease in a medical context does not convey anything to the jury about whether that's a painful situation or not. So just that language change, right? Well, it's not consistent testimony with their complaints. So are you saying they're a liar? Are you saying they're a malingerer? Oh, no, I wouldn't say that. Well, the doctor didn't, it wasn't indicated for the surgery. So you're saying they committed malpractice? You're saying they acted below the standard of care? Again, you can use language as a sword and as a shield, because that defense doctor that gets paid millions of dollars to say, well, I wouldn't do the surgery. So you're saying a qualified board certified surgeon, if they did the surgery, would be acting below the standard of care? Well, no, I'm not saying that. So you're saying that this treater who did it had every right to do it, and they could properly do it based on the findings. It's just you as the hired non-treating doctor who's taking money that has no malpractice exposure and no ethical commitment to the patient says to this jury, seeing them for 20 minutes, you wouldn't do it. But the treater who saw them, who has malpractice exposure, et cetera, had every right to do it. And they didn't do anything wrong. It's just different than your opinion. And then the jury weighs it. So, I mean, there's a lot of ways of using language in life and in law. I don't know how we got off on that tangent, but
That's what happens. I ask you a
it's
question.
good stuff. I mean, it's good stuff. I mean,
How about, let me ask you, you mentioned your parents being preachers. So how do you think having two preacher parents help you be the trial lawyer you are today? That influence.
I didn't think it helped me at all. I didn't think it helped me at all. And then I got divorced. I got remarried. My wife, Gina, that a lot of people know, who's gorgeous, vivacious, multi-bilingual, quadlingual, and on social media and whatever, met my dad before he passed away for about a year. And my dad came out to LA, comes out and would watch trials all the time. And she told me, while they were watching a trial together, that my dad volunteered and said, I see a lot of myself in Mike. And Gina said, what do you mean? He said, well, this is what I would do every week. I would prepare on a Wednesday to give a speech on Sunday. And I see Mike talking to jurors the way, the mannerisms, et cetera, the way I did it. Now, I have never heard that in all of my life, other than about, till about 5-6 years ago. But you think about it. Preachers, rabbis, priests, whatever.
Mark Lanier.
Mark Lanier. Mark Lanier is on every Sunday. And people come to hear him every Sunday. And they got no interest in hearing the same shit every week. So on Wednesday, you start thinking about, what am I going to talk about that's new enough and exciting enough to talk about on Sunday? And do that every week, 50 weeks out of the year, for 50 years. You got to get pretty good at it, because, practice is everything. And I've learned that as well. No matter how good you think you are, you're never as good as you think you are. And there is never a time that practice doesn't make you better. Ever. 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 Why do you go to TLU and to Lanier, and why do you go to the workshops? No, I already know how to try cases. I already know how to do depots. No, you don't. You know how to do it up to the level that you've already had training on, to the level of your practice. But when you're in a stressful situation, just like Navy SEALs talk about, when you're in stress of trial, you fall down to the level of your training, down to the level of your practice. Are you experienced enough to know that when a witness doesn't answer your question after 6, 7 times, what's your go-to response to let the witness know you need an answer and let the jury know? You got to practice that. You got to know how to do it without looking like a jerk. Doctor, I thank you. I really appreciate, but you know, whatever it is that your go-to is, that's a function of practice. That's a function of experience. So I think I learned that from my dad. My dad was the preacher. My mom was the preacher's wife, in the South, in the Christian Pentecostal, it's the dutiful wife with the casserole and the preacher husband and they couldn't make enough money doing that. So most of my life, they were full-time teachers, elementary school teachers, and assistant pastors. And then when my dad retired from teaching for about 20 years, he went back to full-time preaching. And so I got the best of both worlds.
That is, I can only imagine because like my dad was a lawyer, but I realized, he wasn't a mentor like that, but it was just these different experiences people have to get them on the paths we are. And I think the fact that nobody mentored me makes me work harder at this, whole thing, whether it's a podcast, just to help other people, hopefully avoid some of those pitfalls. Because like at TLU, let me ask you though, because like at this conference that went in Huntington Beach, I think you did more workshops than anybody else that was instructing. Because I invited you to come to teach on depositions, which you're going to teach about again in Vegas. But you did what do you out of the workshops and the lectures you attended in Huntington Beach? What would you say the top things that you took away that you were like, oh, I didn't know that, or wow, I hadn't thought about it that way?
Well, there's a lot of ways to skin a cat, right? There's a lot of ways to skin a cat. So I went to his voir dire workshop and I learned a tremendous amount. I learned how he does it. Now I'm not going to do some of the things that he does. Like he's like, I don't kick anybody off the jury usually. I'm like, well, I do, and I probably will always do that. But the philosophy and how he did it and how he taught it was very, very helpful and very useful. But you know, I'm getting ready for this trial next week. I'm thinking about how do I teach the jurors based on the different age groups and generational gaps? How do I come up with demonstratives and how do I use the whiteboard and writing and static boards? How do I encapsulate ideas and themes in using a demonstrative? And that's something that I learned a lot about at TLU Huntington Beach. And the thought process and the creativity is amazing. I've got a T-bone accident, disputed liability. We came in on an open policy, open $100,000 998 in California. Great, right? They were going to pay over policy, but we want a whole lot more. So we're going to try the case. But I got a T-bone accident and a major hip issue and a hip surgery and some future surgery issues. But I mean, how do you use demonstratives in those cases, right? It's a lot easier to come up with fancy demonstratives when you've got a construction accident and you build the set, right? So we're talking about that right now. We're talking about, how do we use skeletons? How do we use the equipment from the surgery? How do we anticipate the cross that they're going to do of our client's social media who uses a cane and has a hip problem and who's dancing at a Beyonce concert with their friends. How are we going to deal with that? I'm probably going to dance at a Beyonce concert. And I'm going to have maybe a cardboard cutout box that looks like a phone. And you're going to show me dancing and look through that phone. But what you don't see that's outside the box is the cane hanging up on the side of the seat. And what you don't see is that I've taken my shoes off because my shoes hurt too much for me to stand. And what you don't see in that is the planning and the looking forward to this. The one time I've seen my friends since the collision, where I used to see them all the time because I just don't feel like it. So hell yeah, I'm gonna film it. Hell yeah, I'm gonna dance. Hell yeah, I'm gonna smile. This is my one shot in the last 1,000 days of problems. And I'm not gonna put on my screen me crying and whining and looking bad and making my friends feel bad. And that is understood more by a certain generation, right? So if I got boomers, I've got, people in their 50s, 60s, 70s, maybe that doesn't resonate as much with them. So maybe I'm looking at a different demonstrative in a different way to resonate with them. So, I mean, these are just thoughts that we're rambling around, right? I learned that creativity, those ideas. I learned from Mark Lanier about road mapping. I'm going to road map for the first time in this trial with cross-examination, but I'm practicing my roadmaps right now.
So speaking of TLU Vegas, so we got TLU Vegas coming up October 16th through 19th. And so what are you going to be teaching? I know you got 2 different lectures and 1 workshop. So let's talk about the lecture first that you're going to be teaching that has to do with insurance.
So in California, Farmers Insurance in-house is a big, big law firm, right? About 250 lawyers, and the managing partner of that has jumped over and now works for our firm and is the managing partner here. The head of Farmers' entire work comp now has jumped ship and runs our work comp program. The lead trial lawyer on their HEAT team, the high exposure trial team, is now at our firm. And so we did a presentation, we're going to repeat it at TLU Vegas, which to me, humbly saying, is the best seminar I've ever been a part of, a best talk that I've ever been in.
Let me hold on 1 second, just so I can be clear. We're going to have the best talk at the best conference that has ever been, October 16th through 19th. Is that, just to be clear?
Correct. That's clear.
Good, because I don't like not to put superlatives, and my whole idea is to really raise the bar as high as I can, at people's expectations, and then exceed them. So that's how we do it.
As I would say, it's going to be really, really, really the best, most amazing, wonderful, stupendous speech ever.
You gotta say, you have to have tremendous in there. Tremendous.
I am the greatest speaker of all time. So what we're learning, how an insurance company is set up from behind the scenes, how claims are set up, how the levels are set up, how reserves are put in, how they mine information, not only in the hundreds of thousands of cases they know down to a very short window of value of certain types of injuries and cases. And then how do you get out of this? You ever wondered why you got an arthroscopic knee surgery and they offer you $23,430.29? Because that's within a very, very window. How do you break out of that? How do you get a better offer? How do you get a better offer faster? Is they also keep track of how lawyers behave. Because statistically, lawyers, like everybody, leopards don't change their spots. And so they know, and we teach what these things are. They know if you don't file until right before the statute, that statistically we can lowball you. You're never going to try the case. You're never going to spend money on the case. They know that if you are pre-lit, have a rear end accident, and the adjuster says, well, the plaintiff stopped early, you're 20% in fault. If that lawyer immediately files, serves, sends depo notices, offers the plaintiff for depo and IME, sends all the records, and makes a policy limits demand, they know that kind of person tries cases. We don't want to mess with them. And then really importantly, they go into what is the system in the insurance industry for people to get credit? How do adjusters and defense lawyers look good? And how do they look bad? And it is not about the money. Because the reserves, as long as generally they keep within reserves, it's interesting. It's not in-house saving $5,000 off of a case. It is about closing your cases within the time frame and generally within the range of what we're talking about. So they're able to give you more money on your case than normal quickly because they want you out of their life because you caused them problems and you are a threat to being over the reserves if they don't treat you properly, right? And so literally, if you look at it differently, if the adjusters and the defense lawyers in-house, they just want to close cases, but they have to do it in a way that allows them to look good for their boss. So they're not going to be able to close a case, certainly for a lot of money, unless they have IMEs and depots and written discovery and all of the records and pre-existing records and all of this stuff, the EDR data. So if you reorganize your practice, and we talk about this and we'll talk about it at the seminar, in a way that provides to the other side quicker, more simply understood, the things that they need, they will give you more money and faster. And now imagine if you have 400 cases, 300 cases, 200 cases, and the average time in your office is 15 months. And just because of the way you learn to do it differently, understanding what the other side needs, you get more money on the case, and instead of it's a 15-month, you reduce it down to 11 months. You have made 40% more money in a year, but your cash flow allows you to do 200 times more than you used to. And that's how you succeed, how you thrive. But you got to understand what the other side is thinking, what the other side is looking for. You got to understand how you behave and how they interpret it. So I hear lawyers come, well, but Mike, my client's still treating, but it's COVID, but I had a baby, but I had a this. It's a great excuse for you, but statistically, they call bullshit because they're not looking at one case. They're looking at all of the cases. And you get put into this bad category thinking you're the greatest thing since sliced bread, not knowing that you're telegraphing exactly the wrong thing. And we talk about when you make a policy demand, you got to go over it, all the things that they look for in good lawyers versus bad lawyers. That's a bad word. In lawyers that they will pay more money to versus lawyers they will pay less money to. It's damn good. If I do say so myself, I'm like, this shit is gold, man.
That's just, that's how I feel about TLU. And I asked somebody, how was it? And they're like, oh, it's one of the best conferences I've ever been to. I'm like, oh, yeah? Really? Compared to what? They're like,
I tell you,
I'm like, does everybody feed you? Is it fun? Do we work on the networking? Ask people to write personal bios, get people connected, providing breakfast that's bacon and eggs and, real food every morning, providing great food at lunch. having games like throughout, having live music every night, having more bartenders than are necessary, so nobody ever has to wait for a fucking drink because we're fucking adults.
That's true.
That shit's
Dude, I saw that right away. Everybody asked me, what's a great party? I'm like, you got to have a dance floor, good music, right? And you got to have a ton of bars. You can't have one or two because the lines are
ridiculous.
ridiculous. You know how to throw a
Right.
party, baby.
And I don't even drink. I'm like, I don't give a shit. I need my.
Me
I'm not
neither.
throwing this party for myself. It's for my guest. It's like what I care about, what I want. Who fucking cares? I'm not
Right.
the customer, and so that's
No, TLU is, and the reason that I jumped all in, I was, like I said, I was president of the LA organization, the largest trial bar that I mean, I was all in the convention every year, et cetera, et cetera. But, times have changed. I mean, the TLU conferences you put on, the reason I want to be a part of them is I see the value, I see the quality of the speakers and the information. And I'm like, you know what? Some stuff's a great party. Some stuff is just great all around in education and a party. And I want to go to this one more than I want to go to this one, right? So,
well.
anyway,
What's the,
not that I'm not going to this one.
no? I'll be
but
there too. I go to them all. But I
I
go to
understand what it is. I understand what it has become.
right. But I live right across the street from the strip now, so it's like. So it's easy for me to go to. I
So
don't have to. I get to sleep in my own bed for every conference in Vegas still, so it's really easy. But
but the other
yes,
speech is also a workshop, and I did it in Huntington, and I'm a law school professor here in LA, and I've taught depositions in law school. I've given this speech. It's on my YouTube channel. It's actually one of the more popular things on my YouTube channel. But depositions are about 30% law and about 70% art. And I'm going to spend in about an hour's talk, hour and a half, maybe. I don't know how much you've allocated.
2 hours.
2 hours, but understanding relatively in an easy, quick way, the underpinnings of why the rules are the way they are, the understanding of why the objections are what they are, right? There's a reason why you don't give certain objections in a depo because there's no judge there. And you can't make decisions without a judge and prevent people from answering questions because by the time you get to the judge, it's too late. So there are rules that say what you can and can't instruct a witness not to answer on. But there are also objections that have to be made at the time because there is no judge and you won't have a judge till later, but you want to give the questioning lawyer an opportunity to rephrase their question because that's the time to do it. That's why form of the question objections have to be made at a depo because that's when you have an opportunity to listen to the objection and say, yeah, let me ask it a different way. But relevancy and legal conclusions and misstates the evidence, I mean, that shit doesn't even need to be made. God forbid if they try to interfere with your depo. So knowing the law and knowing the case law and knowing how the system is set up, knowing that you can stand up and move around and you can get the other side to move around and write stuff down, and you can bring food in, you can do what helps you in a way that I teach about, what you can and can't do and the ground rules. Now let's take that 30% of a depo, that knowledge with that real understanding of why it is, and let's go to the 70% art. And here are the techniques that I can show you how to use different questioning techniques, how to push, how to use an admonition later in the case, in the depo, as a sword rather than a shield, how to control people, and how to, if people aren't going to give answers, how to push them to give answers. And if they really don't want to answer the question, that turns out to be some of your best cross-examination. So then what I'm going to do in the workshop is all of that stuff, we're going to then practice it in real life. I'm going to have some video of my depots showing examples of how I use the law and then those techniques to get people to answer questions, to take control of a depo, to teach a defense lawyer to get out of the way. And then I'm going to have people do it, and we're going to practice it. And so the deposition is a whole speech, and then there's a depo workshop where we're going to take those principles and put them into action.
And for the workshop, the people that register for that, you're going to have 2 Zoom meetups with them ahead of time, so you can kind of show them this stuff. So they show the techniques, give them some transcripts, so that way they're really prepared when they get there, and we're not, watching videos with people actually practicing doing depos, practicing the skill, getting feedback from you, and practicing again, so they actually walk out with improved skills. Is that what's happening?
Yeah, exactly. And there's some, everybody wants outlines, but I'm not going to really do an outline. I'm going to show you the techniques and the skills. And there's also skills when you're preparing for a depo, just like in cross-examination, of how you take notes and work through your notes in a way that allows you to hit all the points you want to hit. And I mean, that's a whole other thing about your trial notebook and your notes, and different ways to organize yourself when you're in the heat of battle, so that you don't lose track, so that you do cover everything that you want to cover. I mean, the same kind of goes for a depo. And then we talk about the mindset of a depo. What other benefits are there of depos? This is usually when you're first meeting the defense. This is usually right after that, when they write their first big letter about the case. How you look, how you act, how you show who you are can materially affect the value of the case by them putting more or less reserves on it, right? Doing things, and then also, mindset of, 98% of the time that depo is never seen again, right? So don't fucking overstress, right? 2% of those cases go to trial, and we stress about asking every goddamn question under the sun at a depo. And I'm like, why? Well, I forgot to ask them how long they lived at that address. Well, then ask them at the trial. If the trial ever happens, who gives a shit? So I see people freak themselves out about depos. And I'm like, you know what? Here are the really good basics and some general stuff. You're going to do great if you use these techniques. Don't kill yourself worrying about, being perfect. And that's resonated with a lot of people, because we're all in the same boat on that. We all have been there, still there. I'm going to be there in about 2 hours.
Right. But before you get there, because we talked earlier, and you told me that you discovered big data at TLU Beach.
Yeah.
So tell us more about that discovery.
So I bought Claggett's book as well, and I listened to what he said. I've talked to a couple other people who do big data. And it's just another thing in the arsenal, right? I mean, everything that we do, you have to run through the prism of your own practice, right? But I'm using some big data analyses for damage cases that I'm trying to figure out value when the defense wants to go to mediation or settle a case, and figuring out if X amount of money is a good offer or not, where it's predominantly a non-economic case. Big data is very helpful for that. I've also learned about how often people focus group in different ways, and just reiterating the extraordinary value of constantly focus grouping cases. And that doesn't necessarily mean a traditional Harry Plotkin focus group. It can be bringing people in your office and going through some cases and seeing how they view a video, or how they view a sidewalk separation, or what kind of evidence would they like to see, and you learn so much. And we often wait right until trial to do these things. And I've learned that oftentimes it's more important to do it at the beginning of a case that gives you a discovery plan, that gives you the questions you need answered. And then what we do is predominantly me, but we've got some really quality trial lawyers here, experienced lawyers. As when we talk about that, we talk about what evidence do we have, and the team's telling, well, I got this and I got this, I got this. And then I come back and I say, well, how are we going to get that into evidence? Well, we got it from the internet. I'm like, well, that's not coming in evidence. How do we take that and get that into an admissible form? Well, and so it's always what knowledge do we have? Then what evidence do we have? And then what admissible evidence do we have? And many times you realize, well, now I got to go take a depo and just ask the right questions. I thought I could get it in, but now I got to go do this. I got to subpoena this. We got to do extra work to get the EDR data in. Maybe that tells me let's get a stipulation from the defense about the EDR data 9 months before trial, and they're willing to give it to me. But if I try to do that 3 weeks before trial, they'll think they'll have an advantage and they won't stipulate. That PowerPoint, that timeline, that I could get into evidence if I used it with every witness in the depo, that by the time I got to the end of discovery, the timeline had been authenticated, and therefore I can use that in opening statement. But if I didn't have that timeline prepared early and authenticated, and I'm not going to be able to use that timeline until I authenticate it throughout the trial, and I can't use it till closing. Well, just thinking about it ahead of time so that you can do the things you need to get it into evidence is a big deal. It's a big deal. But it takes time, and you got practices, you got families, and you got commitments, and you got 300 cases, and you got fires to put out. So then, Dan, we go to the last part of what you and I have talked about, which is, okay, how do you organize your life? How do you organize yourself? How do you take care of yourself? How do you do routines that help you physically, mentally, and in your practice? How do you touch the unimportant things that actually are the most important things? How do you touch the non-fires regularly so that they don't become fires? How do you deal with stress and anxiety and exhaustion? And then what happens when you have a death in the family or an injury or a kid gets sick or whatever? How do you prepare yourself for those trials and tribulations? And if you follow me on social media, you see me in cold plunges and laying on spiked mats and working out at 4 a.m. and, introducing myself to people who I have no idea who they are and et cetera. And a certain amount of people say, well, that's because you're crazy, you're sadomasochist, whatever the excuses that they use to not do it themselves. And all I'm doing is preparing myself for the times when I'm going to be uncomfortable in trial, in life, and say, shit, I know how to do this. I got this. I'm not going to die. I know how when the judge cuts my balls off and tells me I can't do the argument that I had just planned all night to do. I know how to reset and refocus and not freak out and not fall on the ground and instead pull myself back together and argue. I know how to deal with that because I've been doing it every day for my routines. And it's no different getting in a cold shower every morning if you really don't want to do it, but you force yourself to do it. That willpower is no different than when you need to read that depo or prepare for the cross-examination and you really don't feel like it, or you need to file that motion and you're just hoping it goes away, but you really would be better off filing that motion. The willpower to pull the trigger and do the discomfort, the uncomfortable thing, is no different than making your bed every morning and getting in a cold shower and getting in a cold plunge. It's exactly the same thing that goes on in your brain. And if you don't like it, if it's too hard, if it's too uncomfortable, why don't you go over to the 95% of the other people that feel exactly the way you do and let the 5% of us walk right by you? No, run right by you. And I don't see that as a arrogance or anything other than an acknowledgement of real life. And look, you want to not be the 95, it's very easy. You just got to start making decisions to do stuff on this side. And then you'll be just like everybody else, running past everybody else. Doesn't mean that the people that run past are somebody special or super talented or super good looking or well spoken or lucky or nah. The very only common factor is consistent execution on things that are outside our comfort zone. Boom, boom.
But when I talk to folks like Joe Fried and I talked about, mentoring people and giving people a path to becoming great. One of the things we talked about was like the importance of going to conferences and surrounding yourself with great lawyers, because then you start to that's who you run with. And people, because everything that's at this conference, there's 9 lecture tracks. They're all being recorded. And, take and edit those videos and get all the supporting materials, whether it's, transcripts, pleadings, whatever, PowerPoints, of course, and, organize them on TLU on demand. And people are always like, well, don't you ever worry that, from a business perspective, that people are just going to get TLU on demand and not come to the conferences? I'm like, no, because if somebody doesn't understand the value of being in person and the community and the connections and just the relationships, there's nothing I can do to stop them. If they're just a recluse like that and just don't enjoy it. But a lot of times people don't know to come to conferences because their conference experience has always been so crappy their entire careers. I mean, whether it's the state local conference where it's a 1-day thing, or it's, where they never feed you, or it's like some conferences that, I mean, I don't want to.
You should come just to meet me, brother.
That's what I'm
Just
saying.
come over and say
My
hi.
point is that whatever conference experiences they've had that may not have been great, because I've had them. Before I started TLU, I'd go to every conference. And I'd look at it and be so critical of, man, if I ran this place, I wouldn't do X. If I ran this place, I'd do Y. If I ran this place, I'm like, what are these people thinking? But obviously now that I do run the place, I get to execute all of those ideas that I have to, make it.
You have a superpower, I got to tell you. And I've tell you, I've had private conversations outside your presence about how you do have a superpower of putting stuff like this together. You just understand it and you know it and you do it and you execute it in such a way that it's a really excellent seminar. And I'll tell you that people may want to come and go to Nick Rowley's Trial by Human. I would love to do it. I hope that I'm not in competition with that so that I can go to his track. But if there's some overlap and you want to go to Nick's thing, but you really want to hear my good stuff, maybe you watch my stuff on Trial by Demand, right? Or other people. And so I've done that when I was in Huntington Beach, when I'm talking or I'm listening to somebody and I'm missing another thing that I would like to have gone to. The best thing is live, but the second best is then to watch it on, right? But the problem is if you put off so much to watch, it's like that stack of books that's on the side of your bed, right? There's the best intentions to read and watch stuff suddenly get pushed down the road. So you're never going to be perfect, but why not come into a great environment in a great place with great people, with wonderful people that inspire you, with great food, and listening to it live with other interested people? Why not do that? And then if you can add to that with trial on demand, then all the better. And
it's an app for the phone now. So, so now it's so easy, and I'm just in the final stages of building a tool that will transcribe every because I've done probably over 380 webinars and about 6 conferences that were multiple tracks, because you were at the first TLU live event in 2021. But I do have good news and bad news for you, though. You are going to be competing with Trial by Human, because Nick and Trial by Human are teaching all 3 days, 6 hours a day. So he's teaching for 18 hours. But you're also going to be competing or, collaborating, I like to say, with Sean Claggett and the Claggett by Sykes, because they're teaching for 3 days and they got the big data. You're also going to be competing with perhaps John and Alicia Campbell with the jury ball and the big data, because they're teaching for a day and a half straight. And you're also going to be competing with your buddy Brian Panish and Rahul Ravapudi, because Panish and Ravapudi is doing a 3-day track with, their top people teaching what they think the trial lawyer, and everybody's teaching what they think people need to know the most, right? Because we go to conferences because we have gaps in our knowledge. We have insecurities. The people that think they got it all, they don't show up to conferences. You never see them in a class. You would never see them in a workshop because they already know everything. They don't want to mess.
Well, they should go to those long 3-day tracks, but take a break and come over to see
Well,
me.
that's
Go
but
back. Take a
that's
break,
the
and come
idea,
over to
and that's the whole idea is that everybody's got these gaps, and but those, and then Joe Freed, he's teaching, for like, I think Joe Freed's teaching, I think, a total of 12 hours. He's crazy. 12 hours. He loves to teach, though. And so Satch Oliver's launching his book, Depositions Are Trial, and he's teaching 9 hours. It's like these guys are like, but there's like, because Joe, Joe, right, from Atlanta, but that guy spoke 111 times last year. Like, that's even in my crazy world, that's crazy. That's a lot of preparation, but that's kind of what he does to help himself get better. And like you said, of course, it's good for business. That doesn't mean there's nothing wrong with it. Just like I'm working on giving away 100 law student scholarships for TLU Vegas, because like I think about my life and so many people's lives in law school. You never even crosses your mind to become a plaintiff lawyer. And if those people come to Vegas, whether they're first, second, or third year, and they meet people like you and like Sean and like Nick and like Brian and become inspired, they'll have, just like Judge McCrae did for you, we can do for the next generation. And, honestly, use today's world of what it is to do it for a lot more people, to affect a lot more lives.
Let me take this opportunity again. If people are not listening the whole time or taking it, my cell phone is 310-710-3345. My email, cmalder, Charles Michael, CMALDER @alderlaw. My Instagram, mike.alder and Alder Law, and my YouTube is Alder Talk. Any of the above, I reach out, ask for stuff. I got checklists, I got forms, I got depots, I've got everything that you need. And also on social media, we talk about it. That's all the stuff that goes into putting together a presentation for TLU. Then it goes on TLU stuff. Look, the point is that you use it and you find it in the way that you find it. And what Dan is doing is trying to make it as easily accessible as possible, right? And everybody that you mentioned, Dan, is terrific. Everything that they say, they also do their own gig, just like me. But we all also want to do it at Trial Lawyers University because it's such a big exposure to help and expose themselves to so many more people, right? It's not all altruistic. We're not all just, giving our free time. Of course we want to work with people and get business and do whatever. 1,000%.
And it helps the people, because because people are like, they think they got a big case, a great case. I'm like, it ain't a great case unless you got the right lawyer on it. Because other than that, it's just a case. It's just a tragedy. It's something that happened. But so many lawyers who don't have, it takes a lot of experience and resources to do big cases. You got to be able to put $1 million out of your pocket and not sit there and, let it distract your mind, because your mind needs to be freely available to try the case. But that's what some of these big cases
Well,
take.
that's what we talk about at the defense seminar. They're going to tell you what insurance companies and claims people look at to decide whether they're going to pay $3 million or $9 million, or they're going to pay the policy, or they're going to pay, a fraction of it. There are things that they use to make considerations, and there are real things that lawyers can do, real-time techniques and activities that make a substantial difference in whether you get 3 or 9, right? Same case, same facts, same everything, different values because of the way you behave and who the lawyer that you are.
Mike, let's move. Let me ask you, because I want to talk. Well, one more thing you brought up, and then we're going to talk trial. And that is, you talk about dealing with loss or failure. So tell us how you train yourself, because no matter what level you're dealing at, because like, Brian Panch, he sends me these videos, and one of them was do harder, better. He's like, Ambrose, it never gets easier. It's like you think this is, like now people are like, oh, it must get easier. You have this like format. You do it. I'm like, yes, but no, it doesn't get easier because every time I do a conference or an event, I have to outdo the one I did before. And Huntington Beach was freaking awesome. But I have to, in my mind, I have to outdo that because so many people at Huntington Beach will be in Vegas, and I can't disappoint them. I need to be like wow them again, and so it doesn't get easier. But no matter how high level we want to perform at, in ways we still have these shortcomings, these short failures. So how do you deal with that?
So I come to some basic understandings. Basic understanding is that the more shots I take, the more opportunity I have to succeed, but also the more opportunity I have to fail. I also understand that I'll miss 100% of the shots I don't take. I also understand that most of the stuff that I want to accomplish are things that are outside my comfort zone and that I'm not very good at, that I want to get better at. And that means that I'm much more likely to fail at those things than succeed. So then how I talk about failure to myself and how I think about failure for myself means everything to me. Taking more shots and taking more shots that are outside my comfort zone. Because I know the more that I do and the more that I do outside my comfort zone, the higher I'm going to rise. So now I just got to organize myself to deal with the increased amount of failures because I'm doing harder things that I haven't done before. So now it becomes everything. If failure becomes an identity, I'm going to do it less. If I fail and I say I'm a failure, that hurts and I'm not going to try as hard because I don't want to feel that way anymore. So if I can change how I feel about failure, then I can get back in the seat, get back up on the horse. So if failure is an event and it's not an identity, and I truly believe that, and the reason I truly believe that is because I continuously talk that way, then maybe the more events and failures I have, the better it is, because it tells me that I'm actually doing more of the things that ultimately will make me successful. So maybe my wife and I wake up or get at the end of the day and we say, how was your day? And we go, babe, I failed like 8 times today. And then my wife goes, that's awesome. Because we look at it as, that means I'm pushing the envelope, right? Oh, but aren't you just encouraging yourself to fail? Not if you talk about it and think about it in the right way. I'm not trying to fail. I don't want to fail 9 times. But I understand that's the price of admission. And so the key is not to not fail. The key is to fail so many times until you get it right and to stop getting in your way. And everybody cares about themselves and how they're doing, how they look, how they feel, how they act, and ultimately, without overstating it, don't really care about anybody else. I understand family and friends, I get that. But ultimately, at the end, all of us only give a shit about ourselves. When you look at a photo of a group of people, of friends and family, where are you looking first? For yourself. And that's not a criticism, it's a human life, right? So I realize that if I can define my best self and improve the person who I care most about by redefining failure and making myself more able to take and do things that help me ultimately succeed, then I'm going to be successful. And so when people are like, this is hard, I say, thank God. man, this is a challenge. I'm like, wonderful. What a great opportunity. They're like, what are you talking about? I said, well, first of all, if it was easy, then everybody would do it. The key to your success is doing that hard thing. Obstacles aren't in the way. They are the gift of the way to succeed because most people won't take on that obstacle. Fuck, if you just could take on those things and put yourself in a mindset that allows you to attack a problem rather than run from it, and you do that consistently, you're a freaking God. You're unstoppable. I never thought about it like that. Oh, I failed the bar 5 times. You're a fucking awesome person. Who the hell would take the bar the 5th time? What a stud. What a persevering, amazing person to get back up on the horse the 5th time. How many of us would fail the bar a 2nd time and never take it again? 5 times? And that person who I told that to, I remember this. She was like very embarrassed and whatever. And I said, God, that's amazing. That tells me everything I need to know about how wonderful you are. And they're like, what are you talking about? No one's ever said that to me. I said, does anybody here ever think that you would take the bar a 3rd, a 4th, or a 5th time ever? You would give up. You don't give up. Shit, what a gift. And they were so happy. They're like, well, I've never looked at it that way. And now they feel good about themselves. Do that to yourself. Now, I'm not saying be, Mr. Rogers all the time and like delude yourself. Hey, I'm proud to know that I've lost 20 trials in a row. No, not that.
I was going to say, like, that's what you're talking about, word selection and failure and what it means, because, it's like coming up with good ideas. If you want to have great, as I say, if you want to have a good idea, you got to call the person who has the most good ideas is the one that comes up with the most ideas. And so if you come up with 100 ideas, only 1 out of 10 is good. That's 10 good ideas. That's more than most people come up with in a year. And so
it's why my jokes are hilarious.
that was
not because I'm funny. It's just because I tell so many of them. At some point, I hit the mark.
We were talking about dad jokes because I'm in Portugal right now, in Lisbon. And so Mike had this great joke, and he said, what was it about law in Portugal?
What do you call a lawyer who goes to Portugal?
What do you call it?
Lisbon pending. Lisbon pending.
I was like, is that funny? And I'm like, he just made that up. It's not a real,
You got to know what Liz Pendens is
No,
first.
right.
You got to understand what Liz Pendens is.
It threw me off a bit. And then I'm like, I don't know. And then I said, then he made another joke that was another dad joke. And then he told me why he tells all these. So why is it, he tells all these dad jokes because it helps his creative mind. So that's the skill he needs in trial. So by doing it, occasionally the one of them was funny because, like, honestly, the first couple weren't. But I was like, I'm like, interesting sense of humor. But because it's practice for trial. I thought, now that's a good reason to tell dad jokes.
So yeah, I was here the other day, and somebody upstairs, they brought their teenage girls, and they were going to go to Disneyland, stay the night, and go to Disneyland in the next morning. And I totally right off the bat, I said, girls, here's what you got to tell the Disney employees when you come. Say, oh my God, I just got mugged by 6 of the 7 dwarfs. Not happy. And they were like, what the hell? Are you like waiting to tell those jokes? But as I said, I mean, that's a part of your brain, that quick thinking, that changing a bad fact to a good fact, hearing it in closing and reversing it and doing whatever. At least I tell my family, I'm just practicing. I'm building that part of my brain for quick thinking. And they're like, well, could you do it in the other room? Do you mind, not doing it?
So, Mike, this trial you have coming up, can you kind of give us a snapshot of it so that when we talk about the various parts of it, we'll have context?
San Diego, starting Monday.
We're gonna need a few more facts than that.
Right. We got involved after the $100,000 policy was $998. It opened. We came in. to try the case. It got kicked after being ready. We came in right away to try it, and then it got kicked. So we're starting finally, and they've probably done sub rosa between the first trial date and now that we don't have yet. So we're anticipating that. But it's basically a T-bone accident with disputed liability. Our client, uh, we think we're going to show liability on the defendant clearly. Um, T-bone, mid-30s woman, overweight, has, pretty heavy,
About
major hip.
230, about 235, maybe 240 pounds, 5'1".
And she's been that way for years before and still. Um, major hip issues, hip replacements, needs another surgery.
But is
The
this
doctor,
before, hold on, is this before the crash, these hip replacements, hip surgery, or is this as a result of the crash?
all as a result of the crash.
All right.
They say she can't get any more surgery in the future without losing weight. She hasn't lost the weight. And that's what our doctors say too. So there's a couple of big issues, obviously. Weight, in my opinion, is by far the worst discriminatory thing of anything, race, gender, sexual. I mean, it doesn't matter. Weight is number one. And
Well, it
that's been
should be, because in most people's mind, it's a choice. And if somebody chooses not to exercise and overconsuming food, even though, and they don't care about their health, why should the jury? I mean,
And actually, Ozempic and those drugs have made it harder, right? Why don't you take Ozempic? Why? Well, it makes me sick to my stomach. Who gives a shit if it means pain free, right? These are all issues that we're going to have to deal with, and we're working through them. But the judge has kind of a really good judge, but old school in that despite the law, he's limiting both sides to 20 minutes voir dire. So I'm going to pick the jury, and I got 20 minutes to voir dire 18 people, 6-pack. And, the main issue is going to be weight and money for pain, right? We've got their doctors agreeing that up to the time that she's had the care has all been reasonable and necessary. They say that she doesn't need anything in the future, and even if she did, she'd have to lose a bunch of weight. So the first issue is weight, and there's no substitute for taking things head on. There's no substitute for being bluntly honest with the jury, asking them to be bluntly honest. And I'm going to tell them what I thought when I first got involved in this case, before I really got to know my client. I looked at her and I said, why haven't you lost some weight? Isn't this due to your weight problems? After the collision, if you need surgery, why don't you lose some weight? And my opinion was, this is less about the collision and more about her weight. I candidly, right? How many people feel that way? And I'm going to have some graphs, hopefully if the judge lets me use them, to identify those people that are like, yeah. Now, I understand that some people are going to say, well, why would you raise an issue that people may not have thought about? Well, that's a recipe for disaster, because they will be thinking about it when the defendant mentions it 50 times, and you don't want them thinking about it for the first time after that when you can't ask them how they feel about it. But then I'm going to say something like, now I want to change that, because now I've gotten to know my client. Now I've seen the evidence. Now I've seen what we're going to prove to you about what the real reason that she's having all these problems. And I'm saying, okay, now I need to look at this differently with a more open mind and be open to that. But some people still have an issue with at least being open to that. So then how do people feel about that? I don't want to ask questions that are going to have the 230-pound juror go, yeah, I've been discriminated against too, and I hate when people talk about being overweight, because I've just kicked them off the jury. So especially when you have limited time, you're not looking for people to agree with you. You're looking for people who don't agree with you. And the way you sometimes can identify people who don't agree with you is to tell them about real concerns that you initially had. And people who feel that way feel more comfortable in telling, yeah, she's a fatty. Yeah, she's a what, who knows? But then the second point is that money for pain. And I'm working on how do I mix those two, because one of the arguments I see if I was the defense would be, well, you can reduce your pain if you lose weight. You can get surgery if you lose weight. So you want money for something that is okay, it's legitimately hurting you, but you're not mitigating your damages by losing weight. Why aren't you? And the answer of, well, I don't take Ozempic because it upsets my tummy is not going to fly. It's just not going to, it doesn't fly with me. So we're exploring that. Is it too expensive? Is it, we're looking at all of the possibilities, and we're really going to dig deep in it. But at some point, I got to own the case, right? I mean, it's not like at some point you got to understand what you have, and you got to try the case that you have. Now, look, I know, knowing my client, that none of this has anything to do with her weight. These are traumatic injuries. And I know that her future care is a function of whether she's going to lose weight or not, in part. But now I take that bad fact, and what do I do with that? How do I make that a good fact? What a terrible situation to be in. That this person is dictating how she's got to live her life so that they don't have to pay as much money. These people are dictating what she should and shouldn't do in her life. And we know that, a large percentage of the population is above the normal weight. What they're saying is, you know what? Forget your life, forget your lifestyle, forget how you want to live, you no longer have choices. She never would have had to make any of those choices if that son of a gun didn't run the red light. Right? And so, yeah, these are tough issues. The fact that they're so tough puts her in a very difficult position that she never should have had to been dealing with. So if you're thinking about taking off something because she's not doing something one way over the other, then you got to add back to it that they're imposing on her a lifestyle that is no longer her choice. And so, again, how do you then take a negative and make it into a positive? And the same thing goes with the sub rosa. Or not really sub rosa, but the social media posts about, she went to Beyonce. She went to a pool party where she's got a drink and she's smiling and laughing. What does that mean? Does that mean some horrible thing, or does it mean that she's entitled to a couple of hours of smiling, whether it's real or not, whether she's in pain or not? What? You can no longer, if you have a lawsuit that's legitimate, go out with your friends and act like you're having a good time, even if you're in pain? You have to let everybody know all the time how miserable you are?
So, Mike, with this case, though, the story of the opening, tell us about how you go. I know you're trying this with your co-counsel, but you're putting together the opening. So what's your thoughts, on how you should sequence the information and your, visual strategy, and if you use deposition clips like we see a lot of folks do? What you're thinking on how you can do the opening?
Well, a lot of it is going to, depend on what the judge is going to allow us to do. And if we can, we want to play snippets of video from the defense experts, et cetera. But the one thing I think that's really important before you start even talking about strategy is that when you finish with your opening statement, the jury has to understand who the players are and what the timetable is. And I see many times people ramble about all of the facts and they go, I covered all the facts. Well, yeah, and you understand all the facts because you've seen it 3,500 times. You covered all the facts with the jury and they've heard it one time. They don't remember when you say the date of the incident. They don't remember that 2 minutes later. So you got to also do an opening where you're constantly giving them keys to put things into context. So having a timeline or having something written up on the board or whatever of the important dates, having something that talks about who the people are and how they're relevant to the story is important. And having it not just up on the screen and down, but as something that they can refer to in like almost like a key on a map. Right? They're not going to remember Dr. So-and-so versus Dr. So-and-so. So they need a key to know that Dr. X is the orthopedic treating surgeon who did the surgery. They need to know who the defendant name is and who the witnesses are. And so in your opening, one of your jobs, like it is throughout the whole trial, is you got to tell them what you're going to tell them. Then you got to tell them, and you got to tell them that you just told them. And I'm not saying that you talk like a baby, but you do have to understand that these are usually very nice, intelligent people on your jury that are good intentioned for the most part. At least you've gotten the worst intentioned people off the jury. But they don't really care about the case yet. And they don't have an exposure to the case and an interest yet that's going to make them remember all this stuff. So you got to provide them with an opportunity to not only get interested in the case, but to also be able to easily put stuff into context and remember stuff. Which is why, as I told you, that then when you go through the case and you call a witness, you identify who that person is and how they fit into the context of the case so that the jury knows this is now my time to hear this. This is now my time to hear this. And so opening has a lot of different parts of it, right? There's a tremendous amount of finesse to it, but you can't ever underestimate the value of a simple, repetitive, factual, contextual story, especially when the defense doesn't do it. Well, you're going to hear Dr. So-and-so is going to say whatever, and they're board certified, and then Dr. So-and-so is going to come in and say whatever, and then and the jury doesn't remember who these people are in any way. Now, I don't know, the defense lawyer is a good friend. I think I may have told you, he came in to try the case. My first or second trial I ever did as a new lawyer in my own firm 24 years ago was against this lawyer, and I got defensed on a arthroscopic knee surgery. And he was a gentleman, and he took me aside and taught me some things. He took me to a couple of horse racing events, and I really appreciated it. Very kind person, and I've been friends with him for 24 years, and now is our second trial 24 years later.
That is amazing. I mean, what a small world. Small world. Speaking of the trial, though, leading off, what witness you putting on the stand first in your case in chief?
Defendant. Especially in an auto accident case, right? If it's not an admitted liability case, where I'm not wanting the defendant to ever testify at all, right? If the defendant is going to say something in a case, I want them as my first witness. I want to do it for a number of reasons. One, I'm not afraid of this case. I know my case. I'm not afraid of the defendant. Head on, it's go time, baby. Second, I want to make sure that I tie down what their testimony is, especially in situations of speeds and lights and skids and whatever, especially if I have things that I know I'm going to cross them on, right? I want to get that testimony out and I want to put it on a repeatable board, a piece of paper, or something contemporaneously when they say it, so that when I call my accident recon, the next witness or the witness to the accident, the witness to the collision, practice. And I say, here's what the defendant said. There's no ambiguity. The jury is reminded. They know exactly what the defendant said because it's already written up on the board. Why is that not true? So I want to get the defendant committed. Right? And that's really important. Now, obviously, sometimes in more complicated or employment, or you got toxic cases, and, some other stuff, maybe you call it a foundational witness first to give the kind of the context. But the defendant in an auto accident case can get you the information you need to let the jury know where the stuff was, what the roads were, et cetera, et cetera. That's fine. And then you get them committed. And that's our first witness. And that's usually what I do in a personal injury.
So after that, how do you sequence, how do you think about witness sequencing and how you going to, especially in this case, because obviously you got to have some before and afters, I'm guessing, some experts. So it's just, because we only have 2 minutes left because you have someplace to be. So your philosophy of witness sequencing.
Always foundation. You can't expect a jury to listen intently to a damage witness until they at least have most of the decision about liability made. So you can't put damage witnesses on before liability witnesses. And you have to put liability on enough so that the jury says, okay, the plaintiff's going to win. Then when you put on damages, then they are more attentive. If you put on your treating surgeon before your accident recon, and you need that accident recon to really solidify why you should win the case, the jury's not going to really listen to the surgeon until they hear the accident recon. And it's very difficult for people who aren't intimately interested in the case to say, oh, now I know that the plaintiff's going to win. Let me refresh my memory back from, they're not willing or able to do that. So you got to put it in a foundational, but not every liability witness and then every damage witness. Once we feel like we've got most of the liability done, then we can maybe mix it up, right? Maybe.
All right. Well, Mike, you have to go get ready for trial. I got to jump on my next Zoom to help prep a podcast. And I look forward to getting back with you on the 9th. We got to prepare for that webinar. You're head to trial. And thanks for joining us. This is the first, just so you know, this is the first podcast out of the 45 I've done where my girlfriend has been sitting here the whole time, sitting there, paying attention the whole time, because she's like, this is the best one yet. I've learned so much. So just want to let you know that. So thanks for joining us. And
keep talking.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.